Hey everyone, Harry here to talk about Judge Dale Ho's dismissal with prejudice of the indictment of Mayor Eric Adams by the Southern District of New York. Okay, this case has been extraordinary top to bottom, and it ends in extraordinary fashion. Recall the basic outline of what happened. The previous administration indicted Adams on a series of charges having to do with basically a scheme to get money in exchange for favorable treatment. This is before he's mayor of Turkey. The specifics of those charges are really now long beside the point. But the new regime comes in and orders the charges to be dropped. And there's basically a couple things going on. It seems pretty obvious. One is the effort to be able to get Eric Adams to play ball with the immigration policies of the administration. Which would mean, of course, not to play ball or to undermine or not fully serve the immigration policy interests and preferences of his own constituents. There's this unbelievable interview on TV where you may recall Adams and Homans, the immigration czar for the administration, basically acknowledging that they've made a deal, and Homan saying, I'll come after you if you don't keep it, and he's going to do very well for immigration with New York. So very much the appearance of, and this is the one of the highlight lines in the opinion, the long and scholarly 78-page opinion by Judge Ho, who writes, everything here smacks of a bargain. Dismissal of the indictment in exchange for immigration policy concessions. So that happens. And the second reason I think that was in play was Trump's inexhaustible desire to suggest that the previous administration under Merrick Garland was weaponizing prosecutions. How that sort of plays out for the Democratic mayor of New York is far from clear. Indeed, this is a case that's really useful to define and apply what charges of politicized or weaponized prosecutions, which Pam Bondi and the administration just continue to level day in and day out, have to mean. And what they have to mean, in short, is either you have a case where the facts and law point to prosecution and you don't. For some, there's some reasons that might be the case, having nothing to do with politics, but where they don't for reasons that don't apply there, that you're not going by the book, you're not applying justice without fear or favor. Or second, where the facts and law don't point that way and you bring it anyway, the most nightmarish weaponized prosecutions that we have every reason to think the department is in the process of preparing. Adams is a pristine example of the first category. The facts and law are there, and the department orders dismissal for political reasons. This has never happened in, I know, the Garland administration, notwithstanding these completely irresponsible, bogus charges. And here it's front and center. And what ensued, they order the dismissal. The acting U.S. attorney, a Republican, both the U.S. attorney and the person who was leading the prosecution have impeccable credentials, including conservative credentials, and she resigned rather than follow the orders of dismissing the prosecution because she knew it would be corrupt and would be against the oath to the Constitution that she swore. And her assistant U.S. attorney, who was prosecuting the case, did so in even more emphatic fashion and really called them out. And there ensued a back and forth where the acting deputy attorney general had to go to court and do all kinds of fancy stepping and prevarication and obfuscation, etc., of what was already very clear, but they tried to dance around it. And in particular, they tried to add on that the facts were weak in the case, which would have made it a legitimate reason, except it wouldn't hunt because we had the actual, this is what was so solid about the case, we had a letter from the acting deputy attorney general saying in black and white and very foolishly, we understand that the facts and law are here. So that really should have been the end of the matter. Instead, they ordered them for crass political reasons to dismiss. Okay, but they wanted it dismissed without prejudice, meaning it could be revived. And this was the other point that really stank about the whole deal. The prosecution would hang like a sword of Damocles, in the words of the very respected friend of the court whom Ho brought in to advise him. This was Paul Clement, a highly respected appellate advocate and an impeccable Republican credentials as well. And he came in with a long scholarly memo saying, if they want to dismiss the case, there's really very little you can do, but you don't have to do it without prejudice. And if you did it without prejudice, it would look really bad. It would look as if you wanted to hang this possibility of revival of the prosecution over Adams's head to make sure that he did the administration's bidding on immigration. Therefore, I recommend you do it, but with prejudice, meaning case is over, done, can't be revived. So that's exactly what Ho does, and he follows the analysis of Clement in large part. But those are the bones. The meat that he puts on it is very, very scathing to the Department of Justice as these things go. There's a general problem in all these cases that I've talked about, we'll talk about more as they come up, which is judges are loath, sometimes even feel forbidden to just come flat out and identify the fact which is in front of their face, namely the administration here are lying sacks of shit. There's just no two ways about it. They come in with these, complete revisionist history, including here, and they with the new idea, maybe the facts were weak, and the judge said, I'm not going to consider that. It wasn't in the original motion. And you can, his skepticism wafts off the page, but of course he is careful not to go so far as to actually say you guys are lying, but it's very clear that is what's going on and why it's going on. So he says, with some highlights from the opinion, I won't rely on this post hoc rationale that's not stated in the motion. When so much is at stake, the government should really be forthright and turn square corners, as he puts it, when dealing with the people. And he then says it would be a disservice to the public interest. And the disservice in the public interest in this case goes beyond DOJ's reliance on a pretextual rationale. If you read the whole opinion, he doesn't exactly say you guys are lying, but within a half an inch of doing so. And if it is true, he says, that DOJ sought to extract a public official's cooperation with the administration's agenda in exchange for dropping a prosecution, that would be clearly contrary to the public interest. Yeah, no shit. It would be contrary to all kinds of things, but it's exactly what they were trying to do. And of course, at a fundamental level, they were trying to make Eric Adams not serve his constituents and put his own skin in front of them. It would be a grave betrayal of the public trust, also because it would violate norms against using prosecutorial power for political ends. Yeah, no shit. CEG, the standards for the prosecution function. A prosecution should not use other improper considerations, such as partisan or political or personal considerations, in exercising prosecutorial discretion. And that just, is a watchword that's been completely torn to shreds by the new administration. There's just no two ways about it. And Ho realizes there's no two ways about it. So that is what's really most important here. He goes through the whole reasons that it's fruitless to deny the motion because you can't force them to prosecute. But also the reasons why he nevertheless has the power to order it with prejudice and why it makes sense in this case. We could already see this coming when Paul Clement advised him what to do. And what is noteworthy about this opinion is how far it goes. Not as far as some of us would like, in some ways it's not fully satisfying, because the case is so manifest, so screams out corruption, politicization, etc. But this is an important point to kind of process as these cases go up, especially to the courts of appeals and Supreme Court. There's just a built-in norm, you could say, about actually calling a coordinate branch a liar. And you can see why. It's a grave insult. On the other hand, if the shoe fits, we have an administration now that lies all the time, including here. By the way, I didn't even give the full fallout as I was summarizing what happened here. The U.S. attorney resigns, the head person charged with prosecution resigns. It then comes to the Department of Justice. 3 more people resigned rather than do it. And then 30 people from the public integrity section, which since, by the way, has been ravaged and consists of only 6 doing other stuff. This is the crown jewel of the department, are put in a room and basically told, one of you better sign this paper saying, ordering the dismissal, or else. And, the or else seemed very much from the people in the room to be everybody gets fired. So this is the sort of first, because it was early, but the most tawdry, pristine, manifest example of the rotten to the core administration absolutely applying political reasons improperly and then lying about it. That's what happened in this case. And you might never have such a clean example of it because you have on paper, the facts and the law are there. And then a judge going pretty far within the norms of judicial decision writing to call them out, call it pretextual, but use a lot of hypotheticals politely. If the administration's doing this, that would be plainly improper. Everybody can see it like the nose in front of their faces, but that's the way these opinions work. And I just close with that little postscript because that's going to matter. Going down the line, they're going to keep lying. They're going to keep having politicized prosecutions. It's going to be served up for review in the higher courts. And the right answer in a world in which the law takes account of everything is these guys are lying and violating the Constitution. But it will be, as I've suggested before, touch and go with whether the administration with whether the Supreme Court pulls the trigger on those facts and actually says, for example, in these many instances where Trump is invoking national security, but really using it for personal reprisal, how they take account of that without calling them out as liars, or do they in fact call them out as liars? That's going to be a dramatic and important consequence. For now, this case is over. I do not see the administration trying to appeal, as it could, the dismissal with prejudice and say it should be without, it would be an unbelievable fool's errand. And they've gotten beat up badly already. I don't think they are that foolish. They fooled me in the past, but I don't think they're that foolish. So the end of a really ugly, tawdry story that completely indicts the administration for its political ways down to the bones and its lying ways, including calling the previous administration as supposedly having weaponized prosecutions, completely bogus. A modicum of justice is done in this case, at least by not permitting them to get away with making it without prejudice. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.